House.
The question is that the motion be agreed to. I call Charles Cheval.
Thank you, Mr Speaker. Mr Speaker, when this bill was read a first time, my colleagues and I acknowledged that it did contain, as the Minister says, a number of provisions which would assist in the better administration of prisons. But we said at the time that we had a major problem with the legislation, and that was the fact that it permitted the delegation of public powers to private officials. And that hasn't changed. And the Minister knows that that is a major obstacle to allowing the Labour Party to be able to support the legislation. And sir, I have to say that while my colleagues Chris Farfoy and the Honourable Phil Goff have sat on the committee and heard the evidence and discussed that evidence with me and other colleagues, a further concern has arisen around strip searching, which I will refer to later in my remarks. And there's yet a third concern with this legislation now, sir. The Minister foreshadowed the supplementary order paper that she proposes to move in respect of the smoking ban. Very properly, she consulted about that supplementary order paper, but it too has problems, and I will speak to those in my concluding remarks. Sir, I want first to deal with the Labour Party's original main ground for opposing this bill. That is the fundamental objection that we take to involving any actor other than the state in the business of corrections. We believe in a hands-on, active governmental approach to reducing reoffending, and we are concerned about the sort of perverse incentives that introducing the private sector's profit motive to the system will bring. We do strongly oppose privatised prisons, and this bill extends the powers that can be delegated by the Chief Executive of the Department of Corrections to prison managers and staff in privately managed prisons. And that's the fundamental reason, sir, why we can't support it. We believe that prison management, involving as it does the removal of freedom from those who are incarcerated, is and must remain a core role of the state. And it's not something that should be run as a profit-oriented commercial interest. The logic of the system is all about reducing reoffending. The logic of the profit motive is all about expanding the offender pool. And if anybody needs to see the evidence for that, they'll see the powerful public interest groups, the lobbyists that have begun in California and have so effectively for the last 20 years from the interests of those who have managed private prisons sought to expand rather than sensibly contract the correction system in that state. We don't want to see that phenomenon becoming the model that we follow in New Zealand. And sir, international experience simply doesn't support the privatisation of prisons or of other core services. It shows that they don't provide a more effective or less expensive prison system. We think that the motivation for introducing the private sector to the prison system in New Zealand is purely ideological. It won't work. We've warned against it consistently, and we maintain our opposition to it in the context of this bill. And sir, one just needs to look at the experience. Serco, which has some very good staff, I acknowledge that. I visited the facility that they manage in Auckland, and they've got people who really want to do a very good job. But the entire system is built around processing inmates. It's a sausage factory. It simply can't effectively reduce reoffending in the way that we would want to see. And if you look at the controversy, sir, that has surrounded Serco's management of Mount Eden and at facilities in the United Kingdom and in Australia, the logic of this argument starts to become clear. The record of Serco in its first year of operations in Mount Eden Prison has been poor. It's failed to meet 17 out of 37 performance standards, and requiring sanctions to be imposed on it for wrongful detention, wrongful release and escape of inmates. And sir, I was interested to read the other day in The Guardian that the Legal Affairs Committee of the House of Commons has just produced a damning report into a similar attempt to privatise a core function of the state, that is the privatisation of court interpreting services. It's been described by the relevant committee in the House of Commons as shambolic, and MPs have warned that it's caused more trials to collapse and suspects to be remanded unnecessarily in custody. That's the consequence of introducing the private sector into functions that ought to be, by their very nature, the core role of an active state that actually understands its mission and carries out its functions effectively. So a second ground, as I said, of concern emerged during the evidence that was given at the Select Committee. The Minister, I think, was a little selective in her description of that evidence, and this relates to the changes to the rules governing strip searching. They are of grave concern to members on this side, and they form the second basis for our opposition to this legislation at this stage. As we heard in the previous speech, there are currently two types of strip search procedures which can be undertaken under the law. One is for routine cases, such as when inmates have been on work parties outside the prison, and another is a more intrusive procedure where somebody in authority has reasonable cause to believe that there are items of contraband that are concealed on the inmate. Now, in respect of the second type of procedure, there's a more intrusive search procedure permitted. It involves using lights and mirrors to magnify the genital and anal areas of the inmate. The bill proposes to make that second procedure the standard one for all strip searches. Now, this was opposed in particular by the Corrections Association of New Zealand, the association of prison officers, the people who actually work in the coalface in our prisons. They say that more intrusive procedure, making that standard, will be provocative and it will put their officers, their members, at greater risk of assault. We don't want to see that happen. And furthermore, sir, we think that the evidence demonstrates that this more intrusive type of procedure simply isn't necessary. There's been a dramatic improvement over the last 15 years, for example, in the reductions in drug use within the prisons. This seems to suggest that existing search measures are working well and that the more intrusive searching procedure in the case of routine strip searches simply isn't warranted. And sir, this was reinforced by a range of credible submitters, including the Office of the Ombudsman, the New Zealand Law Society and the Salvation Army. They drew attention to the risk of abuse of such procedures, which the Ombudsman pointed out has regretfully happened in the past. So the third basis on which Labor will oppose this legislation is the supplementary order paper concerning smoking in prisons that the Minister referred to briefly at the end of her speech. Now, sir, at the time that Judith Collins introduced the ban, members will remember that we were supportive of it. And we think that it has worked well. I've been to a number of prisons. I've seen that it has a good effect on morale and discipline. Although, regretfully, as far as anybody can measure it, the recidivism rate for people going back to smoking once they leave prison seems to be quite high. But at the time that the ban was introduced, we warned that it should be put on a better legal footing than it has been. The decision was made simply to introduce the ban administratively to allow prison managers to make rules as to contraband and disciplinary offences, and it was asserted by the Minister at the time in her typically cavalier fashion that this would do. Well, she's put taxpayers at risk through her approach, just as she did with the David Bain matter, just as she has with the bumbled appointment of the Director of Human Rights proceedings. And again, we see this cavalier approach coming through again. Mrs. Tolley's been given the job of trying to rescue it, and I pay tribute to her for that. But we're not sure that this provision will actually be effective. The ban has been declared ineffective by the High Court. The supplementary order paper will provide that no proceedings may be brought against the Crown questioning the validity of any rules or regulations referred to in subsection 1. So there are major concerns about whether that's going to be effective, and because we warned about this some time ago, we simply cannot support it.
Time has expired. I call Jackie Dean.
Thank you, Mr.